Cool. Good evening, everyone. So my name is Kolani. I'm a partner in the competition law practice of Bowmans. At the moment, I don't know which office I'm based in, so we'll leave it at Bowmans. So I suppose I have the easiest task today out of the people who will be speaking, which is to welcome you all, not only to this physical space, but I suppose to Bowmans. When I was asked to do this welcome, I must admit, it took me a while to think about what I could possibly say to you. Obviously, as a typical A-type lawyer, there's always the desire to enthrall, to have some value add, so that you can say, well, that guy had pearls of wisdom. I must unfortunately report that after much pondering on the issue, I'm no closer to enthralling you or to having any pearls of wisdom, which is, of course, I think, a marvelous space to be in because I get to enjoy the learning experience of today's panel discussion with you. So you will not hear much about the panel from me. But I suppose it does strike me as useful to think about why the topic of business and human rights is important, both to our firm, Bowmans, and to some extent to me personally. For me, it goes back to why I chose to practice law at Bowmans, and why 12 years later, I still choose to practice law at Bowmans. Over the many years that I've been at Bowmans, I've come to understand that a human rights ethos is at the heart of what we do, how we run our business, and how we advise our clients. It'll be difficult to advise clients with the human rights ethos if we ran our business in a different way. In other words, if conditions of employment for our people are not conducive to productivity and advancement due to some arbitrary practices, if our interventions in high schools, at universities, and consequently our hiring practices do not speak to the lived realities of the majority of South Africans, and importantly, if our procurement is agnostic to how our suppliers in turn run their businesses, if it doesn't talk to that, then we're going to be, we would be in a bit of a pickle. So in this vein, it's important to consider the diversity of our people in all the hues, shapes, challenges, and so on. In other words, the way in which we operate our business should speak to the kind of society we wish to live in, and which our constitution enjoins us to strive towards. While this remains a journey, I'm comforted that we are on the right path as a firm, and are committed to staying the path as the only law firm in South Africa that is a steward on the Council for Inclusive Capitalism, which is a global organization looking to reform capitalism, if you can. Also in this regard, I should highlight the efforts of our head of pro bono, Fatima Laher, under whose stewardship we have an enviable pro bono program, which last financial year notched up over 10,200 hours, valued at over 28 million rand. That was targeting indigent and other vulnerable persons, asylum seekers, gender rights, non-profit organizations, and qualifying businesses and startups through our flagship Ishishini Letu initiative. Bowmans commits to advancing racial equity across racial and ethnic identities facing societal inequality and injustice by increasing the pool of law schools from which we recruit. I know that today, at least what I've been hearing in the murmurs is that it's a Wits reunion. Well, I'm from Rhodes, so at least you've got one person. Bowmans commits to donating just under 3 million rand annually towards supporting secondary schools in underrepresented and underprivileged communities and running a bursary program open to university students, which I have the privilege of chairing. Finally, what I would like to share is, as a migrant worker, because I view myself as one, as a migrant worker from Lusigisigi in the Eastern Cape, the communities that I come from have experienced issues of human rights and business firsthand. From the proposed Tolobeni mining, which has led to deep division and sadly tragic outcomes in some of our communities, to the much hyped N2 Wild Coast project and its impact on culturally significant lands like grave sites. These communities have also been affected by and continue to navigate the complex legal and regulatory terrain of the land restitution program, where large and profitable businesses operate on seemingly evergreen leases with no apparent benefit to the landowners, to the extent, of course, that you can identify who the landowner is in circumstances of communal land ownership. But nonetheless, it remains an issue. I suppose then the question we have to grapple with today is, how do these issues find expression in the sexy framework of the day, what's called ESG, which of course my colleague Jade will talk about later. For its part, the Constitutional Court has recognized that the rights set out in the Bill of Rights are applicable in commercial relations between non-state actors, including in such areas as mergers and acquisitions, much to my let's leave that. So what does this mean for all of us? I'm certain that some of these questions will be ventilated here today, and we'll have much to think about, the very DNA of how we do and run our businesses. So with this, and on behalf of the partnership at Bowmans and all of our staff, I welcome you to Bowmans and to this series of engagements by CALS in partnership with Bowmans. I look forward to walking this learning journey with you, and hopefully together we will end the series when it ends, I think sometime next year, knowing how business and human rights can walk this journey together. Thank you.
All right, thank you so much, Kolani, for that amazing opening and welcoming. Good evening, everyone. My name is Busisiwe Kamolani Khadima, and I am an attorney and research and advocacy coordinator at the Center for Applied Legal Studies. Thank you for joining us here tonight. I'm just catching my breath because I've been running around. But thank you for joining us here tonight for this fantastic discussion, as you will find today that it really is. Let's kick off firstly by saying thank you to our partners, Bowmans, not only for giving us this lovely venue, but also really for partnering with CALS on this very important project. This is the beginning of a series that CALS and Bowmans will be having together that will discuss the very important topic of business and human rights. And one of our hopes is that by the time we finish here, you will all realize that business and human rights isn't a social justice thing that's only left off for people that are in the social justice sector, but that wherever that you are, whatever that you practice, there is space. And actually at the center of the work that you do, you must be considering business and human rights. Whether you're doing competition law, whether you're doing intellectual property, what is the impact of rights in that? And how should you do your work considering human rights? So I mentioned that I'm from the Center for Applied Legal Studies. Just briefly about CALS, we are one of the oldest public interest law organizations in South Africa. In fact, this year we're celebrating 45 years of making a change and impact in South Africa. I think it's brilliant what CALS has managed to do in the past 45 years. And our impact has not only been in South Africa, but it's been across the continent, it's been across the globe. CALS is, in addition to being a public interest law organization, we are registered with the Law Society as a law clinic. We are also a research institution, so we do teaching, etc., because we are also part of Wits University. But really, you know, one of the biggest things that CALS tries to do, or the vision that CALS has, is to try to see a society where there is historical and social justice that is achieved in South Africa. And we do this through 5 key areas of law, 5 key areas of human rights law particularly. And this is environmental justice, gender justice, homeland and rural democracy, civil and political justice, and of course, business and human rights. In these 5 programs that are intersectional, we've done all that we could to make sure that we center marginalized actors. But not only centering marginalized actors, but trying by all means possible to foster critical partnerships with the state, advancing the horizontal application of the Constitution, and of course, ensuring a gendered and intersectional approach in everything that we do. It is our hope as well that in the practice of business and human rights, that these approaches will also be evident in the work that all of us get to do. Our business and human rights program, although it's a department in CALS, really the work cuts across in everything that we do. CALS has led numerous landmark judgments. We've released so many impactful research projects, and we've led timely and crucial advocacy projects at a national, regional, and international level. Our business and human rights program focuses on helping not only communities and affected persons understand their rights as affected by businesses, but it's also about cultivating, as I said, these closer partnerships between communities and business and between communities and the state. Again, this is all for the better advancement of everybody in the country, and with every stakeholder being able to play their part in making sure that we achieve the kind of country that I suppose we all envision to achieve one day. With that being said, I want to introduce to you the experts in this field that we'll be discussing here with us today. And our panelists today are all really, they've sent me 3 or 4 pages of their CVs. So if I was to read all of it, we would be here for quite a long time. But needless to say, our panelists are really specialists in their fields, and you'll understand shortly why they are the ones that are going to be discussing with us today. I have here Gudani. Gudani is one of the members of Makua. It's Mining Affected Communities United in Action. In fact, he's one of the lead project heads of Makua. Makua is one of the largest social community networks in the country. And so welcome and thank you for joining us tonight. Let's give him a round of applause. Next to him, we are joined by Professor Tshepo Matingozi. Professor Tshepo Matingozi is the director of the Center for Applied Legal Studies. And he's also the co-editor of many journals, including the South African Journal for Human Rights. He's also an associate professor for the University of Rotterdam, the University of Wits, and so many other things that he's been involved in. He's a key leader in critical race theory, in critical studies across the country, across the continent as well, and really a leader as well in the business and human rights field. So let's welcome Professor Tshepo Matingozi. And finally, we are joined by Professor Bonita Meyersfeld. Professor Bonita Meyersfeld has published so many things. If you've read anything about business and human rights, you've bumped into Bonnie's article somewhere. So she's really an expert in international human rights law, international law, business and human rights. She's appeared before the Constitutional Court. She's also an advocate of the High Court. She's appeared before the Constitutional Court. She's appeared before, the International Criminal Court. She's founded the Lawyers Against Abuse organization that really helps victims of gender-based violence. And again, she has vast knowledge in this field. So let's welcome Professor Bonita Meyersfeld. All right, now that we've kicked off, I hope I've done justice to, nobody's going to hold this against me to truncate it. Yes, I hope I've done justice to your profile. There's still, as I said, so much more that they are great in. These are our panelists that are here in person, but we're also joined by our panelists that are online. I would love for us to welcome Jade Fayweather, who is from here, Bowmans. So lovely to have you here, Jade. And let's give her also a round of applause. She's joining us from Cape Town. Lovely to have you here with us. And finally, we would like to welcome Douglas, who's joining us from New York. And it's lovely to have you here as well. Let's give him also a round of applause. All right, let's kick this off then. And I think maybe let's start with you, Professor Bonnie. Will you then really talk to us a little bit about business and human rights, and really what does it look like in the context here of South Africa, and a little of your thoughts on where it's gone and some of the key features and key areas of it.
Thanks, Busi. Is this working? Thanks very much. So let me start with 2 caveats. The first is I did not know I'd be speaking in the same virtual room as Professor Castle. Had I known, my preparation would have been far more extensive. I would have been much more nervous. Professor Castle is a doyen in this area of law, and it's really wonderful to be in the same room as you. The second caveat is I was asked to speak about the history of business and human rights, and so I thought that I would be given an hour and a half at least to take you from, you know, really the Knights of the Templar, because they definitely had a commercial component. But I'm going to start a little closer to the current moment, but not so close. 1945, see the end of the Holocaust, and the establishment of the first international tribunals of their kind to actually try war criminals, as opposed to just taking them out back and shooting them. This was the first time there was a pursuit of some type of justice. You can have an argument about whether or not it was a just process. But one of the cases that came before the tribunal was a matter that became known as the Zyklon B case. Zyklon B is a lethal toxic gas that is used for rodent control. It was produced by a company in Germany, and it was provided to the SS, the Nazi army and the Nazi regime, for the purposes of the final solution, which was the mass extermination of Jews in Germany through the gas chambers. And at the end of the war, when the tribunals were looking at state actors, members of the Nazi party, members of the Japanese Imperial Army, there was a moment, really for the first time in history, where they looked not only at state actors, but also at non-state actors, at private persons, and particularly 3 employees, or 1 employee and 2 directors of the company that had supplied the Zyklon B gas to the Nazi government. And it really was a landmark moment, because it engaged so many of the concepts that we see today. It engaged this notion of, you ought to have known. Right? Because the defense of these 3 accused was, we didn't know that our gas, our product that we are distributing for the purposes of rodent control was being used in the gas chambers. And the tribunal said that is impossible. And they made reference to Kolani, the anti-competitive aspects of their distribution network, and saying, you were distributing in this area alone, nobody else was. You knew the amount of gas that had to be distributed there, and therefore you had knowledge for the purposes of accountability. The 2 leading directors were sentenced to death and were killed. The 3rd accused was a low-level practitioner, and his job was to teach the clients how to install the gas. And the tribunal said, no, you don't have that accountability. You weren't in charge of knowing who it was going to, where it was going. You were too low down the pecking order to have any power and authority, and he was found innocent. So 1945 really, for many people, is the beginning of this business and human rights discussion, or this business and human rights field. Fast forward to the 1970s, a decade after decolonization has begun, and you start to see the emergence of a new phenomenon that we understand today as globalization. And globalization sees organizations and corporations, business entities, operating no longer within the confines of their jurisdictional borders, but reaching beyond those borders, right? With their operational base, their headquarters or their area of incorporation being in one country, and then with tentacles moving throughout the globe and operating in other jurisdictions. Thus began a multinational corporation. And following the years of decolonization, there was one country, of course, that wasn't decolonized, South Africa. And in response to apartheid, one of the leading and most charismatic Christian leaders in America, Sullivan, developed a set of principles for businesses operating in South Africa. And he said, if you American businesses are doing business in South Africa with its racial policy of racial segregation, this is how you are supposed to do this. One of the principles, for example, was you cannot have segregation in your dining rooms. Right? You have to ensure that there is racial equality in your operations. And over 100 companies signed up to the Sullivan Principles. Eventually, it became clear that the Sullivan Principles weren't working, and almost all of those 100 companies then withdrew from South Africa. Around this time, is this thing getting all squeaky, or are we okay? Around this time, you also have the development of the OECD guidelines in Europe, which are guidelines on how multinational organizations or enterprises should operate. And you'll see Europe being quite a hub throughout the development of the business and human rights area as one that is taking steps that we don't really see in other democratic, corporate, or commercialized or capitalized countries. And those guidelines, while voluntary, start to set the tone for what your ideal corporate citizen should be doing. And they also created the first taste of a quasi-judicial access to remedy, right? The national contact points. And these are bodies comprised of members of the European states that make up the OECD and non-European, America as well. And these national contact points are points where you can bring a complaint about a particular corporation. So we start to see a little bit edging towards something that's not only about a voluntary principle. Even though these are voluntary principles, there's the beginning of a taste of some type of accountability for non-compliance with the principles. Two things then happen. Vast, indescribable tragedies. In 1984, in a town called Bhopal in India, there is a gas leak. I need to pronounce the gas. I've got it written down here because I can't. It is methyl isocyanate gas. I hope there are no chemists in the audience who are going to rib me about my pronunciation. But this gas is some of the most toxic gas. It remains the worst urban chemical disaster in history. Thousands of people were killed immediately. Hundreds and thousands of people to this day remain disabled, affected health effects that have debilitated their lives, and with babies being born with the continuation of the impact of this gas. There was litigation to try and hold the American-based company accountable for this. There are many ducks and dives of this litigation, with the end result being that there has been almost no compensation to the people of Bhopal today, until today. The second pivotal moment in the development of business and human rights, what many people would say is the watermark, the watershed point in business and human rights, and that is the killing of the non-militant leader of the Ogoni people in Nigeria by the oppressive Abacha regime in connection with Shell's gas pipeline. So the killing of Ken was one of the aspects that brought international attention to this matter, but it was also the reason why there were these protests. And that is because the pipeline that was producing this gas was improperly maintained, resulting in spills that affected not only the health of the people, the Ogoni people who were living there, but also their livelihood. Because the water on which they relied and by which they lived and from which they fished became contaminated. They could no longer fish. They could no longer live. And the entire culture, the entire peoples were facing a potential extinction of the world as they knew it. As a result of this, in the 1970s, the United Nations starts to catch up. Right? And they develop in the 90s, so this is the 1990s, sorry, I said 1970s, they start to catch up. And we see the United Nations in the 1990s start to develop a a body within the United Nations that's going to develop a set of principles, okay? And these are called the norms on transnational enterprises dealing with human rights. And those norms go to great lengths to enunciate exactly what human rights requirements are of corporations, which human rights, which corporations, in terms of which circumstances. And it came very close to holding corporations, particularly multinational corporations, accountable for human rights violations. And it was thus summarily rejected, particularly by global North states. By global North, I'm using it in the World Bank context of those economies that are particularly predominantly in the West, as we know it. The global North states and multinational corporations put pressure on it. It came to an end. And it was at this stage that we have the UN Secretary General Kofi Annan. And Kofi Annan decides he's got to do something. So he develops, together with a Harvard professor, John Ruggie, a notion called the Global Compact. I think somebody's going to tell me I'm run out of time to speak. Okay, so the Global Compact. And many of you may have heard about the Global Compact. The Global Compact, the UN Global Compact, is a series of 10 principles. And I think as of today, 13,000 corporations have signed up to those principles. And I think as of today, probably all 13,000 have been implicated in major human rights violations, demonstrating that there is a significant weakness in standards that are voluntary, right? So if my daughter, who's 9 going on 19, if she were to say to me, leave it to me to regulate what I eat for dinner, okay, we would have, you know, no, worse than ice cream. We would have the Tasmanian devil in the house, right? Leaving self-regulation to the entities that are going to regulate themselves is a contradiction in terms. So the UN kind of clocks onto this as being a bit of a problem. So in his final swan song before going out as the Secretary General, Kofi Annan appoints John Ruggie, Professor John Ruggie, who recently passed away tragically, as his special representative, the Secretary General, to fix this whole issue of business and human rights. And that's when civil society, lawyers, researchers, academics, Doug Castle, everybody gets into a complete spin and starts writing and thinking and doing things around business and human rights. And we are all trying to figure out how to make this work. John Ruggie gets together a team, and the team, I must say, while comprising amazing people, all came from the global North. And with one exception, we're all white. And I do think this was a particular opportunity that was lost to actually have a more representative body within the UN. That having been said, it does not detract from the amazing work that John did with his team. Absolutely amazing work. Why was it so incredible? Because, well, for a few reasons. The first is he brought to the same table UN states, civil society, and unthinkably, corporations. And so for the first time, you really do get corporations, particularly large corporations, particularly corporations like Shell and Nike, which have been caught with their proverbial pants down, to a negotiating table about how to ensure that businesses comply with human rights. And over many years of consultations, John Ruggie finally releases a set of principles called the Guiding Principles on Business and Human Rights, resting on 3 pillars. Can I carry on? Boring? Stop? 2 minutes? Is somebody else going to do the guiding principles? Essentially, the guiding principles say, 1, states have the primary duty under international law to ensure that human rights are respected and protected, right? So I, as South Africa, am bound by international law to make sure that corporations under my jurisdiction do not, for example, ban trade unions, suppress free speech, discriminate against employees. So I have that primary duty. But, say the guiding principles, corporations have a responsibility, a loose version of a duty, a responsibility to respect human rights. So there's no direct accountability, but really you've got to start paying attention as a company to both your own corporate practices, but also your supply chains, the origin of your products, and to ensure that when you are working in volatile situations like conflict zones, that you take certain steps to ensure that your operations do not exacerbate human rights violations in those contexts. And finally, there must be access to remedies. So those are the three pillars. As soon as that report's released, there's another pivotal moment. Should I stop there or can I quickly finish it? Pivotal moment. Pivotal moment. Pivotal moment is when you see this whole movement of business and human rights start to fracture. And on one hand, you have the development towards a treaty, a binding treaty on business and human rights, pushed predominantly by the Global South and civil society. On the other hand, you see a push towards implementing the guiding principles, people saying, we've got something that works, let's try and implement it. And this tension has developed. But we also see the most incredible developments at the national level. So we have the French duty of care legislation, Frank Dodd Act in the United States, the Modern Slavery Act in the United Kingdom. And last but most certainly not least, we have Section 8.2 of the South African Constitution. Section 8.2 of the Constitution says that juristic persons in certain circumstances and in respect of certain rights may be liable for the fulfillment of the Bill of Rights, and that you want to watch very carefully in respect of your clients. Thank you.
Thank you so much, Professor Bonita. And I think this ties in quite well, Professor Tsepo, if you can touch them. Professor Boni spoke a bit about how there's sort of a political climate that also affects how the development of business and human rights becomes. Can you speak a little bit more about really the political context of then business and human rights?
Good evening. Can you hear me? Yeah, I'm asking because I've got allergies, so my nose is blocked. So please excuse me. I can listen to Bonnie all day. Excellent. So I want to talk about the political context from two perspectives. The first perspective from our perspective as CALS, but also then from a global perspective. I think, as we know, one of the main political contexts is the fact that big business has become more powerful than states. I mean, if you take a company like Apple, a company like Amazon, a company like Total, just those companies alone, their worth is more than the GDPs of all African countries combined, together. So, historically, as we know, as Bonnie said, the duty bearers for rights has been the state. But then, politically, there had been this need to then hold big business accountable, because the more powerful they got, the more atrocities they committed. Let me start with a small story. I used to work for an organization called Kulumani Support Group. So Kulumani Support Group is a social movement of about 100,000 survivors and victims of apartheid who came together in 1995 to create this movement just before the setting up of the TRC. Anyway, in 2002, they instituted a lawsuit against 22 multinational companies. 2002, 22 multinational companies. And the lawsuit really was about charging these companies for aiding and abating the crime of humanity called apartheid, 2002. And really, this was one of the first cases that was litigated in the United States, because there was no legislation that we could use in South Africa. So we had to go to the United States of America using a legislation there called the Alien Tort Claims Act. A very old piece of legislation from the 18th century, very, very old. So we used that legislation to charge these companies for aiding and abating apartheid. Companies in the, I won't mention the names, but in the motor vehicle sector, computer making, banks, and so forth, 22 multinational companies. The case went all the way to the Supreme Court. And in the Supreme Court, we were successful, partly because the court just had to say, the case must go back to the court, Accra, because almost half of the judges had to recuse themselves because they had shares of association with those companies. So the link between the judiciary and big business, very, very clear. The case, we eventually lost the case. And we lost the case partly because the South African state does something very unprecedented in the history of this type of cases. The South African government sends an affidavit to court to say, please dismiss this case. Right? So the South African state standing against victims of apartheid on the side of big business. Please dismiss this case. This case was litigated before the TRC, or these matters were ventilated before the TRC, but also this type of matters will scare away investment, right? Investment. Well, it's not true that these cases were before the TRC. If a big business stayed away from the TRC until there were special hearings, and some of them went there. So we lose this case partly because of two reasons. One, because of this affidavit from the South African state, but secondly because the US legislators changed the legislation so that you cannot hold companies, American companies, liable for acts that are done overseas for human rights. So they changed the legislation to make it very narrow. Lessons from this case for us. The first lesson is this coalition between big business and the state, that it is sometimes very, very difficult for your own state to do their duty to hold these companies accountable because of this very close relationship, let's call it a relationship, between big business and the state. The second lesson for us was that even the sending countries, meaning countries that are where these companies are coming from, where these companies are headquartered, they have an interest to protect those companies, their own companies. So you can't even rely on them. You can't rely on those, on those states. The third lesson was that the voluntary mechanisms were useless or are useless in terms of, hold these companies accountable. So from a political perspective, we made a distinction between business and human rights framework and the framework of corporate accountability. The framework of corporate accountability, but two are not the same. The first one, business and human rights from a political perspective, says that you can have inclusive capitalism, perhaps, right? You can have capitalism with a good face. Corporate accountability is an understanding that what leads to corporate impunity, what leads to business being complicit or sometimes committing, these atrocities, is because of corporate power and the power of neoliberalism. And that if you are going to hold corporates accountable, law is sometimes not enough. Law is sometimes not enough. You need to really engage in a political battle, which is mental corporate power. So that's why I'm glad that Gudan is here to talk a little bit about that. The second thing that I want to say is, from a political perspective, the phenomenon of so-called state capture, right? The idea that not only are states who focus on attracting investment, but they want to hold companies accountable, but sometimes that business interests dictate your legislation, dictate policy, state capture. So that's why we need the international treaty, right? A treaty that can be binding, that can hold corporates accountable. But the last thing is that, politically speaking, it's not only that corporates can capture the state is that for us in the global south, the condition of possibility for many states is the company, So if you go back to the history of South Africa, there's no understanding of South Africa without big business, right? For example, colonialism 1652 is made possible not by a state, but by a company called the Dutch East Indian Company. If you fast forward, you go to the creation of South Africa in 1910, when the four colonies came together, it was a business decision, right? That those colonies must come together. So you have the creation of this thing without a name called South Africa, 1910. We know apartheid, also a business case, what you do with, poor African people. And most importantly, the transition to democracy of South Africa, in the context where the ANC is not winning, the NP is not winning, this is very, very central. Political negotiation. So we have a very good constitution, but at the same time, a neoliberal transition. So what does it mean for us, those of us who work in social justice? In context where you have a very good constitution, but that is immediately undercut by neoliberal context, a very capitalist context, right? That we cannot even, in the past 30 years, with very good cases, nothing is changing, right? Very good constitution, socio-economic rights within available resources, but nothing is changing. But also in the context where more and more of the state and big business, you can't make a distinction. So that's why, as we speak today, our business and human rights team is not here. They're in Geneva at the negotiations for the binding treaty. So we support the binding treaty, not because politically we think that the law will dismantle corporate power, but law used together with social mobilization is the step forward to corporate accountability. So for us, the political context is two main things. One, the phenomenon of state capture, and also secondly, the idea that corporates very, very difficult to hold them accountable in one state. Therefore, there's a need for this international treaty. Thank you.
Thank you so much, Professor Tsepo. That was really a mouthful. And I think, both of what yourself and Professor Bonita was saying, the impact of corporations in South Africa is not a theory. We read about these things, we understand the context, international and locally, but it's not theoretical. The impacts are lived experiences of many people within the country. And so I want to reach over then to you, Kudani, just to speak a little bit from a community's perspective on the impact of business and really what the role is then of communities in trying to push back on the impact then in your lived experience.
Okay, thank you. Can everyone hear me? All right, thanks. Yeah, I think I didn't get the proper memo. I didn't know I was going to be in the panel with professors. And particularly my first year lecturer here, Professor Tsepo Madlingos. So I'm quite under pressure. But yeah, thank you so much for having us as the community. I think this is the first step and a step in the right direction. So I think firstly, let's begin where everyone has witnessed it, the whole world, in Marikana. So Marikana, I think it's one of the worst forms of an expression of the relationship between business and human rights. Because you see business in collusion with government, as Professor Madlingos just alluded, making sure that the interests of business thrives over the interests of the Black and the poor. And you also see the extent at which capitalism and neoliberal policies can go. Because, for example, the community in Marikana had been engaging with the mines before the protest to say to the mines, we are the ones that are mostly affected by your mining activities. Can we at least benefit? And the context, can we at least benefit? It's from a request perspective, of which it should not be a request, because there is legislation that obliges mining companies to ensure that the communities that are affected by their activities are benefit from those mines. But then, as if ignoring the communities of Marikana, business, referring to the mines in Marikana, also went to the extent of killing miners who were simply requesting or asking for a minimum wage. And that minimum wage, if you are to weigh it with the working conditions and the workload that those miners had to endure, it doesn't even come close to equaling that. So that is the first time where we see in a public space where business actually spits on this notion of human rights. But then it carries on and on. So as Makua, what we do is we have these things called social audits. So we go to communities that house mining companies, and we look at their social labor plans. Look at, because for a mine to exist in a community, they must first have a social labor plan, which has promises. So these are actually promises, but they are bound by law to do that. So they must have a social labor plan where they have promises of things that they are going to do in the community. For example, they can say that we're going to build schools, we're going to improve the economy, we're going to employ the people around here. And this is so they can mitigate the impact, environmental, social, and so on, of their activities on the communities that house them. So with social audits, what we do is we capacitate community members on this social labor plan, because the social labor plan there isn't a social labor plan that we've come across that is less than 100 pages. Deliberately so, because they know that the communities that house them are not literate enough to understand everything that is written there. So what we do is we summarize those social labor plans, and then we host workshops in these communities and capacitate communities on what the social labor plan is and what actually the mine is obliged to do. Thereafter, we go to, we do door-to-doors. So we have questionnaires where we ask community members. For example, there will be questions like, have you or someone you know benefited from this project? And then we come up with a report. And in almost all the reports that we have, we've done about 8 social audits across the country. In almost all the reports that we have, community members are saying only one thing: the mine does not talk to us. Which takes us back to what Sbuzikote says, the president of Abathali Basam John Dola, that everyone wants to talk about the poor, but no one wants to talk to the poor. So these mining companies continue to violate the law, continue to violate the rights of community members in these various communities without any repercussions. With the report that we have, we realize that firstly, there isn't consultation, which is one of the main pillars of, I wanted to say our constitutional, but it is not my constitution. So I'll say of your constitutional dispensation. Because the constitution speaks about accountability, responsiveness, and openness. That is the foundation of public consultation. But this means, because they know their relationship with the state and they know that they have protection, what they do is they go and pick up few people. They pick up the councillor, they pick up the traditional leader, and then they pick up this one person that is well known in that community. They consult them. That is the public in their eyes. Then after then they go back to the DMRE and say, we have consulted and people accept our social labor plan. whilst the community on the ground knows nothing about that. And what is more painful is that, which Vuzigote also refers to, that the Black people and poor people have no other avenue to explore. And businesses know this. That's why they perpetuate this colonial mentality that you should not speak to Black people. You can speak for Black people, you can decide for Black people. Because they know that if you take them to court, for example, with Makua, the only representatives that we can go to is CALS. You go to CALS, CALS also has other cases. You go to Lab for Human Rights, they also have other cases. With these big corporates, they have capital. They can afford the top high-billing sentence lawyers. That was not a shade, sorry, I forgot where we are. I forgot to read the room, I'm sorry. So that's the reality. Then you go to, for example, we were in a village called Mapila with CALS. They were conducting a business and human rights workshop. Just after everyone had left, because what we do is we normally have branch developments in every workshop that we have. And the community in Mapila have been writing to us, telling us that, you guys, the mine, Mokgalakwena mine does blasting. And when they do blasting, if you have never experienced it, you are going to run. Then, unfortunately or fortunately, when we were there, before we could leave, they started doing blasting. It feels like an earthquake. And if you've experienced an earthquake is nothing closer to a tremor. It's earthquake. Start experiencing everything shaking. When you look outside, it's dark. You can't see anything. So then you think about the people, for us, that was very devastating. For us, who have only been there for like an hour, who experienced that thing for like an hour. Imagine the people who experienced that thing for every day of their lives. They've been speaking to the mine, they've been trying to get the mine to mitigate the effects of that blasting, but it is not happening because of what? That business mentality that we cannot speak to these people, we'll speak to them through government, of which the government has a relationship with business, and government cannot fully represent the interest of the communities. So one thing that has really worked for us is mobilization. For example, currently the Department of Mineral Resources and Energy want to explore a relationship with private companies again through the privatization of electricity supply in South Africa. They're currently conducting public hearings on this electricity regulation amendment bill. We wrote to them before and said, can you please postpone, because the time frame, so they announced the dates on the 16th of September, and the first date of the public hearing was 26th of September. We wrote to them and said, guys, that is not enough time for people to study this bill, understand it, and fully critique it to be able to make informed presentations at these public hearings. But as always, Black and poor people cannot talk to them. So they ignored that email. And then our next step was, we've been attending all these public hearings with them. It has got to an extent where when we get to the venues, they don't even search us, they call us colleagues, because we are with them in each and every one of them. And what we are killing them with is that wherever we go, we mobilize the communities, then we quickly capacitate them on the impacts of privatization, which is essentially the impacts of business on human rights. But then the communities themselves, they go to the forefront, to the podium, and make representations based on what they know. But still, because of our communities are poor, and so also we must also look at the impact that the impact of poverty, because business understands that these communities are poor, and they also take advantage on that. Because, for example, they isolate people. If they see that there's a key person there, they employ that person in the mine. Then that's what degenerates the struggle. So also in these public hearings, what they're doing is they take buses and take people to those hearings, and then those people, when they get there, they just say, we accept. So what you ask them, so you accept, why do you accept? They tell you, yeah, no, we are tired of load shedding. There's no direct correlation between what they are saying they accept for and what the bill is for. What we have seen is that with this mobilization, when you mobilize communities and you let them to be at the forefront of their struggles, then it is definitely going to put a spark on the struggle. We have had different media trying to get to us, to interview us, and so on, because we have created that traction through what getting the community members to be at the forefront of their struggles, which is what business and government doesn't want to do, which is to let Black and poor people talk for themselves, decide for themselves, and negotiate for themselves. So that is the experience of communities, particularly poor communities and mining communities with business, and how their human rights are violated. We can honestly go on and give various other examples, but I think my time is, yeah.
Thank you so much. Thank you so much. Extremely important. Centering people affected, centering communities should be everybody's central practice. With that being said, I think let me hand over to you, Professor Douglas, who's joining us from New York and who's also part of the Business and Human Rights Association. What role then internationally can, key players then play in addressing some of these issues, that's already been mentioned? And what are some of your thoughts as well from your perspective?
Well, first of all, thank you very much for the opportunity to participate in this panel with people who have varying but tremendous expertise in the field of business and human rights. I had the pleasure of visiting Johannesburg last week and met with distinguished attorneys at Bowmans. And I've known, of course, of CALS for many years. John Dugard is a global hero for many of us. I also appreciate the kind words from Professor Meyersfeld. I'm a recovering academic. I taught for 30 years in various law schools, including topics of business and human rights. And when I finally came to my senses and retired from law school, I went to attorneys I knew at a global law firm called King and Spalding, and told them that I wasn't, which is where I am now, and told them that I wasn't going to retire from Notre Dame and let the law school where I was then teaching, unless King and Spalding wanted to have a counselor on business and human rights. And the answer was, when do you want to start? And I started 5 years ago. And my purpose was to see whether what I had been teaching in law school had anything to do with reality in the real world of corporate lawyers and big corporate law firms who advise multinational corporations. After doing that work at King and Spalding for several years, I became involved a year ago, a little more than that, in organizing the Business and Human Rights Lawyers Association, which announced its formation at the United Nations Global Forum on Business and Human Rights in Geneva last November. We started at that time with 22 law firms, mostly large global law firms. We are now up to 44 law firms, including in South Africa, Weber Wenzel, and we're in preliminary discussions with a number of other South African firms who we hope will consider joining the association, certainly including Bowmans. On this panel today are represented at least 3 of the strands which are necessary, in my judgment, to improve the performance of companies with respect to human rights. I don't think there's any one single silver bullet. There's no single constituency. There's no single legal measure. There's no single discipline that by itself can move the needle very much when it comes to improving business performance with regard to human rights. But trying all of these approaches together and simultaneously, it seems to me, has the best chance of moving things forward. If I were to pick one spark that seems to me to be the most important, it's the kind of thing we just heard from Mr. Gudani Chikota, and that is organized advocacy in support of communities by nonprofit groups and community groups that are close to the people on the ground. They care the most, they know the most about what's happening. Without them, the movement that we've seen in other areas, in my judgment, would not have taken place anywhere near the degree that it has. A second important area is voluntary movement by companies and by the lawyers who advise them. And I'll come back to that because that's what I do these days, mostly. And a third is the movement toward hard law, toward law that actually requires companies to improve their performance. We heard earlier mentions of the French law, of some efforts to use the United States courts under an old law, which is no longer usable, unfortunately, in the United States. Discussion of the treaty. But what's happened in the last, and some other laws, what's happened in the last 10 years or so is that what used to be pretty much soft law, that is non-binding law, under the United Nations Guiding Principles on Business and Human Rights and the OECD guidelines for multinational corporations, which have incorporated the UN Guiding Principles, is gradually becoming hard law. In terms of across-the-board legislation, the French led the way in 2017 with the Loi de Vigilance, the law of caution or due diligence, you might say in English. 2 years ago, we had both the Germans and the Norwegians adopt broad-based laws. And now the European Union, for the last couple of years, has been drafting and debating and negotiating a proposed corporate sustainability due diligence directive that would require all 26 EU member states to adopt legislation that would require companies to engage in human rights due diligence and would make them accountable in a court of law if they cause human rights harm. So what used to be a good thing to do, what used to be morally right, what used to be encouraged by soft law is increasingly being encouraged by hard law, and not only in Europe. All of the examples I just mentioned are in Europe. I could mention others elsewhere, but for large multinational corporations, much of the European legislation applies to companies that do business to a significant level in Europe. And many, maybe most, I haven't done a count, of large multinational corporations have a significant footprint in Europe. And that requires them under these varying legislations to improve their human rights performance, not just in Europe, but globally and worldwide. And so if it comes to pass that the treaty negotiations in Geneva for the United Nations treaty that Professor Madeleine Gozi, and I apologize for my pronunciation, mentioned, if that treaty negotiation does not come to solid fruition soon, the regional initiative in Europe is going to be very important. Also in the Americas, the Inter-American Court of Human Rights has ruled in a litigation in 2021 that the states of the Americas that are parties to the American Convention on Human Rights are obligated to regulate their companies in accordance with the UN guiding principles on business and human rights. For those who are interested in more information on this, I might mention that a committee of the International Bar Association, of which I was a member of that committee, has drafted we tried to make it 3 pages. I think it ended up being 6 pages, something like that. A short summary of the state of the law globally and the movement in the law globally for approval by the Council of the IBA at its meeting in Paris at the end of this month. It's been approved by various committees along the way. I hope it will be approved within a few weeks. And I've also written a significantly longer article for the International Chamber of Commerce on the process of soft law on business and human rights hardening into binding law. What about the approach of hoping that law firms like Bowmans, which is one of the leaders when it comes to human rights, and law firms like King and Spalding in the United States and many others, the 44 that are members of the Business and Human Rights Lawyers Association, how much hope should we place in their efforts? We shouldn't count on them to get the job done. The job requires much more than that. It requires pressure from below, as I mentioned. It requires state regulation. It requires astute analysis by academics like Professor Meyersfeld. But there is a role to be played. The United Nations Guiding Principles on Business and Human Rights apply to all businesses, all companies, large and small. And the larger the company, the more responsibility it has to adopt a human rights policy at the highest level of the company, usually the board of directors, to implement human rights due diligence, not to wait until some problem arises, but to conduct studies of their business operations and their supply chains and their value chains to attempt to identify in advance not the certainties of human rights violations, but the risk areas, taking into account the countries in which they and their supply chains do business, or their value chains, including the downstream recipients of their products and services, incorporating into their business plans at an operational level means to avoid the risks which they identify or minimize them, reporting publicly on those risks, engaging in ongoing consultations with the communities affected or potentially affected by those risks, and ultimately cooperating in remediation in the event the risks do materialize. So all of that is the responsibility of companies, but it's also the responsibility of lawyers in 2 senses. Number one, it's our responsibility to advise our client companies of all of these responsibilities of theirs. And secondly, it's the responsibility of the law firm itself as a business to make sure that it is itself aware of the human rights risks posed by its own activities. Everything from what kind of computer hardware you purchase and where it comes from to opening new offices in questionable regime areas. When I came to King and Spalding to try to find out what the real world is like in corporate law and corporate counseling of businesses, what I quickly found out was that in this law firm and in other large law firms, including those that are in the BHRLA, the Business and Human Rights Lawyers Association, very few lawyers know even the soft law, let alone the new hard law. My firm, for example, has about 1,300 lawyers. If I can find 10 out of those 1,300 who could give you a pretty good summary of the UN guiding principles on business and human rights, I'd feel pretty good. And that's not to knock my firm. I think the same thing is true in all of these big law firms, or almost all of them. And so the reason we formed this Business and Human Rights Lawyers Association was precisely to try to make the many other lawyers in these big firms who advise corporate clients who don't know about the UN guiding principles and the responsibilities of businesses under the principles, to educate them about these principles and to educate them to the fact that this is not just some niche area of practice to be handled by 3 people sitting in some corner of a law firm with a specialization like other people's specializations. This is a cross-cutting responsibility of all lawyers in a firm in all areas of practice, whether it's competition law, whether it's tax law, mergers and acquisitions, project development, regulatory, you name it. The human rights responsibilities of companies come into play in all of those areas. And so to the extent any of you might be law students, and I can't see too well from looking at the audience through this little teeny screen that I have, but to the extent any of you are law students, I encourage you to get a running head start on this issue and learn about business and human rights while you're in law school, and then keep learning when you get out, because this is a dynamic field. It's going to be much more developed 5 years from now than it is today, and then 10 years, and so forth. So thank you very much for the opportunity to join your program, and congratulations on initiating this series of webinars on a very important topic. Thank you.
Thank you so much, Professor Douglas. So many important points, and really to touch then on lawyers really getting involved in business and human rights, and lawyers really understanding what it is, especially in the shift to hard law. I think we'll hand over to you then, Jade, really for some of your thoughts on this as a lawyer who is in corporate practice, and the importance really of tying in business and human rights even in the work that you do.
Thank you so much. I think just to reiterate what we've been made well aware of this evening is the synergy between business and human rights, which becomes apparent when we consider the profound impact that businesses have on the well-being and dignity of individuals. I'm going to briefly discuss ESG in South Africa, because within the corporate realm, ESG is a powerful catalyst for the advancement of human rights and significantly assists businesses in helping the country achieve a more equitable society. From environmental sustainability and responsible governance to social inclusivity, the pillars of ESG inherently touch upon the very fabric of human rights. Because in corporates, I mean, we know that every action that is taken, every investment that is made, and every policy that is endorsed has a ripple effect on the lives of South Africans and, of course, individuals worldwide. So in essence, ESG stands for environment, social, and governance. So in terms of environmental aspects, this spans, for example, across climate change, energy consumption, water scarcity, biodiversity preservation, pollution control. Social aspects include labor rights, diversity, health and safety. And lastly, the governance aspects concern compliance with laws, anti-bribery and corruption, and corporate structure and management. So human rights imperatives for business include protecting individuals from unfair discrimination, ensuring equality and inclusivity in the workplace, fair labor practices, protecting communities from being negatively impacted by business operations. So to ensure that the environment for individuals is not harmful, which is really the embodiment of what ESG in South Africa tries to achieve, ESG in South Africa and globally. As everyone is well aware, South Africa's constitution is one of the most progressive in the world. So the Bill of Rights affirms democratic values of human dignity, equality, and freedom, but it also enshrines the right to an environment that is not harmful to the health and well-being of the people, and several socioeconomic rights such as job opportunity, equality, and including the right of access, for example, clean water. In terms of the legal framework of ESG in South Africa, regulation in this regard has been a key driver. we do not have a dedicated legal framework that solely focuses on ESG compliance, but rather legislation and guidelines that incorporate ESG principles. So if we look at general ESG compliance in South Africa, we have the King IV report on corporate governance, which outlines principles for companies to consider when they conduct businesses and publish their annual reports annually. And basically, King IV seeks to impact organizations at a board level by encouraging principles related to effective and ethical leadership. And while King IV is largely voluntary for most companies in South Africa, public companies whose shares are listed on the JSE are obliged by the JSE listing requirements to apply King IV and report on their application in their annual integrated reports. And as I previously mentioned, King IV is not legally binding to non-listed companies, but that doesn't mean that non-compliance with it will not have any consequences. So courts may consider King IV when they evaluate what constitutes good governance practices, particularly in cases that involve governance duties. And this may potentially lead to exposure of the board to liability under certain circumstances. So King IV is a prime example of ESG compliant legislation that encompasses the synergy of business and human rights, as its principles aims to address employee welfare, sustainability in both the environment and in areas of job stability, and also ensures legal compliance with South African legislation. Secondly, we have the Social and Ethics Committee, which is a requirement for companies operating in South Africa beyond a certain measured impact level. And what this committee has is the responsibility to monitor and report on things such as social and economic development in a company, good corporate citizenship, the environment, health and public safety, consumer relationships, and labor and employment. So the committees would look at how the company is applying certain international labor practices, such as the United Nations Global Compact principles. How is the company complying with local laws, such as the Employment Equity Act? And these laws fundamentally address human rights in of themselves. And the requirement to appoint this Social and Ethics Committee, I think, really highlights that companies of significant scale bear a societal responsibility that extends beyond mere profitability. In terms of more industry-specific sectors, the financial sector in South Africa has really been a leader and an innovator in integrating various ESG issues into practices. So really focusing on this idea of the right to a safe environment for individuals. So just to give you a few key examples, we have Regulation 28 of the Pension Funds Act, which basically requires pension funds that to consider ESG factors, especially those that materially affect the sustainable long-term performance of their assets. And this basically ensures that an entity has the ability to conduct its business in a manner that primarily meets existing needs without compromising the ability of future generations to meet their needs. So a very nice embodiment of what the financial sector in South Africa is really trying to achieve. We have the prudential standards, which again takes into account many factors that may materially affect sustainable long-term performance. We have the Public Investment Corporation Amendment Act, the Code for Responsible Investing in South Africa, which again guides institutional investors in developing and implementing a sustainable, responsible, and long-term investment strategy. If we look at the financial sector's role in society, they have a very crucial role in capital distribution within the country. And the sector is quite integral to achieving this sustainable development that we're talking about. And generally speaking, institutional investors and asset managers are taking these steps to improve integration of ESG into their operations. And while those I've just mentioned specifically apply to the finance sector, many companies can and very often do leverage a lot of guidance from these regulations to steer their own internal activities, ensuring that they're aligned with these ESG principles. And ESG principles are actually largely already embedded in the various legal frameworks that South Africa has, and the South African frameworks that govern businesses' operations already. So if we look at the environment aspect, we have acts like the Carbon Tax Act, imposing a carbon tax per ton of carbon dioxide that is produced on certain listed activities. South Africa has extensive labor laws which are aimed at ensuring fair and equitable treatment of workers. We have significant data privacy laws, and then the governance ones I mentioned are King 4 and the Social Ethics Committee. And I think just to touch on some of the key factors that encourage businesses to adopt these ESG approaches, South Africa has implemented quite a few frameworks and guidelines that's aimed at encouraging business to adopt these ESG approaches. So taking a look at a few would be the Green Finance Taxonomy, which applies again to the finance sector and allows financial institutional investors to define certain assets as green if they if they meet certain sustainable thresholds. We have the Sustainable Development Goals, which South Africa adopted because of their membership to the United Nations, setting out 17 sustainable development goals, which basically calls on countries to take action which ensures sustainability and includes a specific human rights focus. So it looks at addressing things like poverty, zero hunger, good health, well-being, gender inequality, clean water and sanitation, peace, justice, and strong institutions. And then the National Development Plan, which was implemented by the South African government and basically is the embodiment of these sustainable development goals I just mentioned. And then I think what's important is to take a more practical view on things. And, you know, ESG compliance is also largely driven by investor demand. So for South African companies to actually connect to global markets, there is this increase in regulatory pressure to comply with these ESG standards. And a key example would be the International Regulation of Corporate Sustainability Reporting Directive, which basically mandates companies within the EU and non-EU companies that have an EU subsidiary meeting certain turnover thresholds to provide a comprehensive data set on their sustainability performance and various climate risks that they're facing. So basically just highlighting that while South African companies don't have a dedicated framework of ESG laws, they are impacted by global ESG compliance laws. And it's important for us to consider them in order to stay relevant in these markets and enhance our international relationships. And then I think public awareness. I mean, the South African society and global society is increasingly aware of environmental and social issues, with large amounts of civil society organizations and advocacy groups pushing for this responsible and sustainable corporate practice. But I think while we have these incentives, there are also discouraging factors that somewhat deter companies from complying with ESG, especially when ESG compliance